कॉन्सेप्ट्स पढ़ाएंगे, सबको सिखाएंगे is a very leading campaign of iExamB, which is going to clear all of your important concepts for all the subjects. Conceptual clarity is the key for clearing any competitive examination. इसीलिए हम लोग लीगल बी पर भी इस सीरीज को चला रहे हैं and we have covered near about 19 concepts. This is the 20th concept, that is from CPC that we are taking up today, res sub-judice and res judicata. इस कंसेप्ट के डिफरेंसेस सिमिलैरिटीज़ को हम बहुत ही आसान तरीके से समझेंगे इस वीडियो में. सो डू वॉच दिस वीडियो एंड ऑल्सो इफ यू हैव एनी क्वेरीज यू कैन राइट टू अस इन द कमेंट सेक्शन ऑफ दिस वीडियो. Welcome to iExamB, welcome to iExamB's Legal B, and also don't forget to subscribe to our YouTube channel and stay updated. अगर आपके कोई भी queries हैं आप हमें hello@iexamb.com पे लिख सकते हैं. You can call on this number and also visit on our website for more details relating to all the exam preparation courses. अब स्टार्ट करते हैं कंसेप्ट से. रेस जुडिकाटा रेस सब जुडिस का जो कंसेप्ट है काफ़ी इंपॉर्टेंट है सीपीसी में से. सेक्शन 10 एंड 11 ऑफ सीपीसी इनकॉर्पोरेट्स बोथ ऑफ दीज डॉक्ट्रिन्स. बट इसे अगर हम एक सिंपल लैंग्वेज में समझें तो ये कंसेप्ट है क्या. ये इमेज आपको दिख रही है. दिस इज अ कोर्ट सेटअप. वन मोर इमेज आई विल शेयर विद यू. व्हाट इज दिस? दिस इज द हैंड ऑफ अ जज and this is something which indicates that he is pronouncing judgment. He is deciding the matter. अब इन दोनों images के थ्रू हम ये समझेंगे कि res sub-judice और res judicata क्या है. If you look at the first image, you can make out that the matter is ongoing before the court of law. The parties are being represented before the judge and the matter is something which is ongoing. And in this image, if you look at it, this is a process which is showing us that the judgment is being delivered and the matter is being decided. So ये दो stages हैं एक case की when they are before a court of law. One stage is that the matter is ongoing and another stage is that it is being decided. तो इतना सा ही difference है res sub-judice और res judicata में. इसके अलावा कुछ भी नहीं है. Res judicata is the first image that the matter is ongoing and res judicata is the second image that the matter is already decided. इन दोनों concepts, इन दोनों doctrines का basic origin same है and objective भी same है. सिर्फ difference इतना ही है कि दोनों में एक former जो suit होता है that is ongoing in res sub-judice and it is decided in res judicata. Now, what are the requirements for these doctrines? आप res judicata और res sub-judice को कब apply कर सकते हो? What are the necessities for it? Firstly, when the matter is directly and substantially in issue. It is between the same parties and the parties are litigating under the same title. Courts are competent and are having jurisdiction. Now, what are the meaning of these necessities? Let us see point by point. Matter is directly and substantially in issue का मतलब क्या है? हम यहाँ पर res judicata और res sub-judice की जब बात कर रहे हैं हम दो केसेस को कंपेयर कर रहे हैं. तो इन दो केसेस में से हम एक ही केस चलाएंगे क्योंकि दोनों भी केसेस में जो मैटर है जो इशू है वो सब्सटैंशियली और डायरेक्टली सेम है. अगर एक ही मुद्दा कोर्ट में बार बार जाएगा सो ये कोर्ट का टाइम वेस्ट करेगा और इसका कोई सेंस नहीं बनता है. सो वी विल चेक वेदर द मैटर इज डायरेक्टली एंड सब्सटैंशियली इन इशू इन द अर्लियर सूट. वी विल चेक दैट वेदर द मैटर इज बिटवीन द सेम पार्टीज and whether both the parties are litigating under the same title. That means whether plaintiff is plaintiff only and defendant is defendant only. अगर ऐसा होता है कि पहले मैटर में plaintiff है वो प्लेंटिफ दूसरे मैटर में डिफेंडेंट है तो मैटर लिटिगेटिंग अंडर द सेम टाइटल में नहीं आएगा और रेस सब जुडिस और रेस जुडिकेटा एप्लीकेबल नहीं होगा. नेक्स्ट इज दैट द कोर्ट्स मस्ट हैव competent and they must have jurisdiction. And अगर jurisdiction same नहीं है तो भी res judicata और res sub judice apply नहीं हो सकता because we have provisions for revision, appeal and all those things that are not affected by this doctrine because that time the jurisdiction of the courts changes. So ये कुछ necessities हैं जो दोनों ही doctrines में required है. Section 10 and 11 of CPC को देख लेते हैं. Section 10 talks about res sub judice. Sub judice means that the suit which is filed later will be stayed. It is talking about stay of suit because एक suit already pending है, ongoing है. Res judicata कहता है कि एक suit already जब decide हो चुका है तो आप decide होने के बाद वापस उस matter को लेकर court में नहीं जा सकते. That is what is talking about bar of suit. Stay of suit and bar of suit are the simple words that you can use for both of these doctrines. Section 10. Now technical words we can see. This rule with regard to stay of suits is when the matter is under consideration and is pending for adjudication by a court. And res judicata is when the matter is already adjudicated. That means it is already decided. And it bars the trial of a suit second time on the same issue when the matter is substantially in issue, parties are same, court is of same jurisdiction, then the trial is barred and the adjudication in the former suit will stand as valid. अब समझने की कोशिश करते हैं कि इनके क्या क्या ऑब्जेक्टिव्स हैं या रीजंस हैं. सेम ऑब्जेक्टिव्स हैं दोनों भी डॉक्ट्रिन्स के लिए. पहले तो हमें ये समझना होगा. ऑब्वियसली both the doctrines are based on the same concept and the same objective. The only difference is what we have already seen in the first slide, that the matter is ongoing or decided. बस इतना सा ही difference है. We cannot waste court resources and time. We already know that the court is overburdened with so many matters. And if one matter is already decided or is already being entertained by one court, then why will another court put its time and effort and resources on that? Next is avoiding conflicting decisions. We have many courts and we have enough faith in judiciary. So we cannot take conflicting decisions from both the courts and then that will be a mockery of judiciary. We cannot multiply suits unnecessarily. We need to avoid this multiplicity of suit and judicial decisions need to be accepted as correct. As we respect judiciary, we have faith in judiciary, that's why we approach to a court. If we have some problem with the decision of a court, we can challenge its decision. We can necessarily challenge it, but in the higher court. We cannot just do trial and error for the same thing in jurisdictions, in courts that are having the same jurisdiction. ये एक simple सा logic है और यही ये इन दोनों doctrines का objective है. So this was all about section 10 and 11 of CPC that I could explain in the simplest language for all of you. Concepts पढ़ाएंगे, सबको सिखाएंगे. कैंपेन के अंदर आपको ऐसे सारे ही concepts में clarity मिलेगी. And do write to us in the comment section if you have any doubts. And don't forget to subscribe. Prepare 50% faster with iExamB. Thank you so much everybody.